Hello, so in this tutorial I'm going to be focusing on some key areas for tort, and for those of you studying the OCR specification or the AQA, these are the main areas that you need to revise for your A-level exams. So I'm going to be covering negligence, occupiers liability, private nuisance, rylands and fletcher, and vicarious liability. Now, on the OCR paper, there tends to be 5 questions. So it doesn't take a genius to figure out that you have 5 areas, 5 questions, everything will come up, because it's very, very unlikely that OCR would repeat one area across 2 questions. Now, at the time I'm recording this, for those of you watching, your essay for this year is going to be on occupiers liability. So I've covered some evaluation points in this tutorial on occupiers liability. If you want to re-watch my tutorials on the law of occupiers liability in more detail, then please do that first before you go on to the evaluation. I haven't covered negligence evaluation in this tutorial, but I will do another one at some point on that. So what I thought I would do first of all, and because this is revision and I'm covering quite a lot, I'm sorry, there's quite a lot of text on this PowerPoint, so please do, like I advised you with the criminal law revision tutorial, please do make sure that you spend time pausing and writing things down, so don't feel like you have to keep up with me, okay? So what I've done on this slide is what I call like a whistle-stop law summary for each area. Now, to gain level 4 marks for assessment objective 1, which is your knowledge and understanding of law across the A level, you need to make sure that you are citing key law, and you need to really aim for 5 citations if you can. Now, obviously, as teachers, we teach you far more than that, because there are a large number of cases. Remember, we're studying a legal system where most of our law is based on precedent. There are a large number of cases, and in many areas there is also key legislation. So there is more to learn, and those of you that can learn more should please don't cap yourselves to 5, because when you're applying law to scenarios, you're going to get more marks if you can use relevant cases. And there may be scenarios based on cases that perhaps you've excluded from your revision. So what I've done is put all of the main law on this slide, but I've actually highlighted, if at this late stage, let's say you're watching this and you haven't got long before your next exam or assessment, if at a late stage you feel like this is too overwhelming to learn all of these cases, then what I've done is highlighted in bold the key laws that I would learn. Okay, so for example, if you look across at negligence, we know there's a test. So you have to owe a duty of care to the claimant. You must have breached that duty, and then that breach must have caused loss or harm to the claimant. Okay, so I've put the 3-stage test across the top here, but what I've done is highlighted some key cases there. Of course, there are more that you'll be able to see, and if you can use those, brilliant. But as a minimum, those ones in bold I would learn. Okay. For remedies, there isn't as much, and I've highlighted some there. So I've highlighted a case for damages, so compensation. I've highlighted a case for orders and a case for injunction. So all of the main remedies that you would find in a civil action. The 2 main defences that we learn on the A level are contributory negligence and valenti, meaning consent. So I put some key cases there and the main act for contributory negligence. And then for occupiers liability, which is a bit of a bigger area because it's got legislation and case law. So of course, as a minimum, you need to make sure you put the main acts. Okay, so you've got Occupiers Liability Act 1957, and then the Occupiers Liability Act 1984, depending on whether you are talking about visitors or trespassers. Now, for absolute detail, impressive A-star detail, I would expect to see subsections. So if you see here, Section 1, subsection 2, Section 1, subsection 3, the duty of care is under Section 2, subsection 2, and then it follows on. So for children, the duty owed to children, and then the duty owed to tradespeople, and the rules in terms of independent contractors. Under the Occupiers Liability Act 1984, you have under Section 1 the detail. So Section 1, subsection 3 lists the requirements that need to be satisfied for a duty to be imposed on an occupier. Section 1.4 are the factors that may affect the liability, and then Section 1, 5 and 6 list the two kind of main defences, warning signs and valenti. Now, if you can't learn that detail at this stage, so the subsections, and I've tried here to put them in order if you see, I don't know if that helps you, hopefully it does, but if you can't learn those subsections, then as a minimum, learn Section 1 and Section 2 for Occupiers Liability Act 1957, and then for the 1984 Act, Section 1. So you see I've put those at the top, the headers, underlined them. So there are ways of being able to cite legislation and perhaps still being able to get into level 4 without this finite detail. But as I say, I've put them in order, so 2, 3, 2, 2, 2, 3A, 2, 3B, and then 1, 3, 1, 4, 1, 5, 1, 6. Hopefully that's easier, or that makes it easier for you to learn. Okay. Private nuisance is quite a big area really because it has a lot of case law, and I caution against not learning this amount of case law because when you're applying the law in a scenario, there will be specific facts. So the interference that gives rise to a private nuisance might be smell, vibrations, light, noise, that kind of thing. And you're going to get more marks if you're able to give a supporting case that highlights that example of nuisance, if that makes sense. I have put in bold Hunter v Canary Wharf properties and Tetley and Chitty because, first of all, you need to establish who the claimant is and who the defendant is in the scenario. I have put Halsey against SF Petroleum because that illustrates that a private nuisance could give rise or arise from direct interference, but then the other examples are indirect, so smell, noise, vibrations, etc. coming from a neighbouring property are examples of indirect interferences, whereas Halsey, part of that case involved damage to a vehicle, so that was direct. Okay. What also increases the number of cases in this area is where you have to decide whether the interference is unreasonable. If you believe it's unreasonable, then it's unlawful, and that kind of is another hurdle that you have to overcome when establishing liability. And there are a number of factors that you can consider there. So was the interference done with malice? How long did it go on for? Was it a natural interference? Where is the locality? The closer it is to the claimant, the more likely it's going to affect them. But also, how sensitive is the claimant to that nuisance? So the court won't always protect sensitive claimants. Okay, so again, a couple of those might come up in a scenario or one, and it's going to strengthen your answer if you're able to cite the relevant case law. And then we have certain defences as well. Okay. Vicarious liability is a bit smaller, but there's quite a lot of recent case law that I would make sure that I put in. So obviously you have to establish, because vicarious liability is about holding a third party responsible. So an employer is responsible for the actions of their employees. Okay, So the person who's committed the wrongdoing, the tort, must be an employee, and you've got 3 tests that can help you to establish whether somebody's an employee. Those tests come from Ewan, Stevenson, and Ready-Mix Concrete. Or this is a more recent change, 7 years ago, in a position akin to employment. So you look at what they're doing. If what they're doing benefits the employer, then the court may rule that that person is an employee. Okay, and that's from Cox and Ministry of Justice. But there's a case that involved Barclays Bank that said independent contractors are not employees. I think a lot of employers were worried after Cox and Ministry of Justice and felt that that was too wide. So that has been reduced. So, a couple of recent cases there can really help you with that top level detail. So you establish the employer-employee relationship first with those cases. Secondly, you have to establish that the wrongdoing occurs in the course of employment. Or if it's in a criminal act that's been committed as wrongdoing, that only needs to have been connected to the employment. Okay. Secondly, is it fair and just to find the employer vicariously liable? And that comes from Morrison supermarket case. And then there are also some factors to consider from another more recent case called Christian Brothers. Okay, so if there are any of those key cases that you're not familiar with, please do make sure you look them up. And then finally, the Rylands and Fletcher environmental tort, kind of commonly known as a bit of a strict liability tort as well. So this is a neighbouring tort again, but this is all about unnatural material escaping from the neighbouring property onto the claimant's property and causing damage, and that damage must be reasonably foreseeable. Okay. There are rules where the damage has been caused by fire, and there are some defences as well that can be raised. 2 main ones here that I often see in scenarios are: has it arisen from an act of God? So in other words, kind of weather, extreme weather, unpredictable perhaps, or an act of a third party. Okay, so I hope these summaries help you to start with revising your AO1 and understanding of the law. Okay, so let's focus on occupiers' liability for a little while, because this, at the time of recording, is a key area for OCR this year, because your essay is going to be on this. So if you look top right, you need to make sure that you've got the key acts. Please don't write an essay or a scenario without key acts. And of course, you have the occupier, who needs to at least be in possession of the property, of premises, which usually includes fixed or movable structures, but there is case law to suggest that a premise could be a lake as well, Tomlinson, and I've seen that in a scenario too a couple of years ago. Visitors can be invited to the premises for a number of different reasons, perhaps a contractual invite, maybe a licensed invite. Please do watch my tutorial if any of this is new to you. I've got 2 parts of occupiers' liability tutorials on my channel. Or perhaps the person claiming is a trespasser, so that in essence they've exceeded permission in going onto premises. Okay, so I've set out the key law underneath each area. On one of my tutorials for occupiers' liability, I do kind of set this out in more of a diagram, which you might find a bit easier than a table. So we have to establish that there is a duty of care, and that duty of care is only to make premises reasonably safe, and that's for visitors and trespassers, in fact. But what goes over and above for the 1957 Act is that if the visitor is a child, the premises must be made safe for that child. Although the courts will take into account where a child is younger, that they should be supervised. So if they're not being supervised up to a certain age, then that will go against the visitor. Okay, so it's probably going to be the parent or guardian that are bringing the action anyway if a child is injured on premises. So the court will certainly take into account whether that parent or guardian was supervising in the first place. If the visitor is a tradesperson, a duty is still owed to that tradesperson, but of course, if the injury is related to what they're doing there, they are expected to safeguard themselves against risks, and those risks that are known. In terms of defences, there are quite a few. So contributory negligence, you could argue that a visitor has contributed to their loss or harm. Perhaps they've consented, but only if they're fully aware of the risks, they understand them. A warning sign put up will give a defence, but only if it's understood and it's clear. Exclusion notices as well may serve the same purpose. As an occupier, you may be able to pass liability onto a third party, or what we call an independent contractor, if a visitor has suffered injury because of the work done by them. Okay, so if you had a company or somebody come onto your property, carried out work, and then a visitor was injured as a result of that work being faulty, then as an occupier, you could pass liability onto them. Okay, but there are requirements that have to be satisfied for that, and I've summarised them here under section 2(4)(b) at the bottom. So you'll be able to pass liability on if it was reasonable for you to give them work, if you believe that they're competent, and that's insofar as you can check that they're competent, and you've checked the work is done, again insofar as much as you can, because of course we wouldn't expect occupiers to have the expertise that an independent contractor would have in carrying out work, because otherwise they'd do it themselves. For the trespasser law, it's a little bit straightforward. So occupiers owe trespassers a duty of care, and that's if requirements under section 1, subsection 3 are met. So the occupier has to be aware that a danger exists. They have to have reasonable grounds to believe that a trespasser is in the vicinity, and at risk of danger. Okay, and I've summarised the law there. Also, they have to be expected to provide protection against risk, so it's a reasonable expectation. So, I mean, a lot of people think it's unfair that occupiers owe trespassers a duty at all, because if you choose to go onto somebody else's premises or land, then surely you're taking that risk, and therefore, if you're injured, you should not be able to make a claim because that's your choice. So that's why these requirements are here. It is quite strict, and it is making sure that an occupier will only be liable if they know that a danger exists and they are expected to provide protection to anybody who comes within that danger, against the risk of harm. Okay, so it's not a blanket, they owe a duty of care to trespassers. There are requirements that have to be met. If it's established that a duty is owed, it is only to take reasonable care. Okay, so not expected to spend loads of money, for example, in preventing these risks of harm. So that would really depend on the facts. No mention in the Act is made of any additional protection for children. So the reasonable care is for adults and children the same. Okay. There will be factors that can affect liability. So if the danger is obvious, then a trespasser may not be able to claim. But again, if a danger is obvious to an occupier, that could go against them. So it really depends on the facts. The visibility on the actual day in question where the trespasser has gone onto the premises, that could affect liability. The cost of taking precautions. Of course, an occupier is not expected to spend lots of money in safeguarding against risks. And similarly to under section 1(3), if an occupier has awareness of the trespasser being in the vicinity, and or the danger being there, then they may more likely be liable for a claim. Warning signs can be a defence as well, as can voluntary consent, probably less likely to succeed for children, but certainly for adults, those two can be quite strong defences. Okay, so in summary, we've kind of got who the parties are, occupier or visitor or trespasser, the premises, and then what I've got in this table is the duty, when the duty will be owed, and what the defences are. Okay, so we've kind of got 5 or 6 structured areas there. Okay, so this is the bit that a lot of you have been asking me for, the evaluation points, okay, because the essay is an important part of your exam this year. It is 25%, and we know it's coming up for OCR, okay? So there's a lot of text on here, so again, take your time to write it down. But essentially, I would structure an essay in exactly the same way that I advise you to structure your law. So I would start by setting out the key law. So visitors offer protection under sections 1 and 2 of the Occupiers Liability Act 1957. Trespassers are owed protection if requirements are satisfied under section 1 Occupiers Liability Act 1984. So instantly you are setting out the key law and you're gaining AO1 marks straight away. Marks for law, okay? Just note what I say at the top. Typical essays in this area focus on effectiveness and fairness of the protection offered to trespassers, because that is quite a contentious issue. Should we offer protection to trespassers or not? How effective is the protection offered? But also in previous years, there have been essays around the effectiveness of the protection offered to children. So the fact that under the 1984 Act, there is no additional protection offered to children, yet children are more likely to trespass. Is that an issue? Okay. So what you could do once you've read through these points as a task that I've put top right, add in more key supporting law to complete your essay, because I have referred to some in this slide, but I'm mainly focusing on evaluation points. Okay, so back to the main part of the slide. So you start your essay with the key law, and then you could go into the meaning of occupier, the meaning of premises, the meaning of visitor, and the meaning of trespassers. All those first key points that we looked at in the summary of law. My evaluation of all of these things, is that the meanings are wide. Okay, the meaning of an occupier is wide. They only have to be in control of the premises. The meaning of premises is wide. The fact that it could include a lake, I think, adds to that. The meaning of visitor is being wide. You have many categories of people that can amount to being a visitor, and the meaning of a trespasser is wide. Anybody who exceeds the permission of an owner. Okay, so what does it mean in terms of evaluation if these meanings are wide? What it essentially does is increases the likelihood of liability for the occupier. Okay, which then, if we develop that further, makes that unfair. Okay, if they're more likely to be liable because the definitions within the law are wide, then that is unfair to them. That potentially makes the law ineffective. Okay. Next, you could talk about the duty. So again, following the structure of the law as I took you through on the previous slide. The duty of care across both acts is only to take reasonable care. Okay. We could probably argue this is fair. We don't ever want occupiers or expect occupiers legally to spend lots of money and time in over-assessing precautions, albeit we live in a society now probably where we do over-assess precautions and health and safety. But it's probably fair to say we only expect a reasonable duty of care. Although what is reasonable will be viewed subjectively. This is bound to change from case to case. which can make this area or this part of the area inconsistent, difficult to predict. If you're being advised by a lawyer, you're an occupier, and you're saying, is what I've done going to be viewed as reasonable? A lawyer may not be able to give you a definitive answer. Equally, if you're making a claim as a visitor or a trespasser and you want to know whether the occupier will win, whether they actually will be deemed by the courts to have taken reasonable care, again, it will be difficult for your lawyer to advise you that definitively. Okay, so it makes it inconsistent, which then can lead to ineffectiveness. Okay, so remember, we're always saying what it leads to. That gives us more marks for development. Always link back to the question. Leads to ineffectiveness or effectiveness, or fairness or unfairness, or justice or injustice. Okay. And then, depending on the essay question, you can talk about the 1957 Act or the 1984 Act. Now, a question may ask you to focus on one of the acts, so trespassers or visitors, or it may be more open-ended. I can't really predict that for you. There have been both assessed in previous years. So the protection offered to trespassers under the 1984 Act is restricted. There are requirements that have to be satisfied in order for occupiers to owe trespassers a duty. That provides protection and limits action for occupiers who safeguard against risks and who don't know trespassers in the vicinity. So that arguably is fair. That is effective because it's limiting vexatious claims. Okay. However, they don't offer additional protection for children. Perhaps that's unfair because children are more likely to trespass. So you could turn that on its head and say maybe there needs to be more protection for children. There's probably quite a lot you can write there in a paragraph. Remember, if you need to pause and write these things down, please do. The protection offered to children is given under the 1957 Act. And as I've said here, the protection is the same for children and adults under the 1984 Act. Children need more protection, so this needs to be fair. Okay. Case law holding parents responsible if they're not supervising their children is also arguably fair. So you've got Phipps, you've got Jolly, v Sutton LBC. Those cases all illustrate that the courts are not just going to hold an occupier responsible if parents or guardians should have been watching their children and supervising them. But it is subjective because it depends on the age and the understanding of the child. There is no definitive, if you're 8 years old, we expect you to be supervised. If you're 12 years old, we don't. Okay. So that can make it difficult to interpret. And again, for lawyers and people bringing actions to have more of a definitive understanding of what the outcome would be. So protection offered in terms of tradespeople and independent contractors is limited fairly because there is an expectation that professionals will safeguard themselves against risk. And if you're employed to carry out work as a professional, there is an expectation that that work will be competent. And if it's not competent and people end up being harmed, then you should be liable, not the occupier who's employed you to do that. Okay. It's potentially unfair, though, to expect occupiers to check the competence of work carried out, because, as I said previously, if they understood that work, then perhaps they'd have been able to do it themselves. The reason why you hire a professional is because you haven't got that knowledge and expertise yourself. Okay, and then finally, the warning signs. So how effective are they? They provide a defence, which is good, although again it's subjective because the effectiveness of a warning sign in being a defence depends on the understanding of the person who you wanted to read it. The visitor or the trespasser who is claiming, did they understand the sign? How clear was it? Okay, so make sure with these paragraphs that you're linking back to the question, and at the end you draw an overall conclusion, again linking back to the question, but also suggest reform for further improvements. So you might say, as a suggestion, perhaps provide more protection for children. Add something into the legislation that does that. Provide more guidance where we have these areas of subjectiveness, these areas of lack of clarity. Perhaps we could provide more guidance in the legislation or through case law. Okay, so you've probably got, in terms of paragraphs, in terms of your essay, your first paragraph could be around the meanings. So you could just lump together the meanings of occupier, premises, visitor, trespass in one paragraph a case. That could be paragraph 1. Talking about the duty of care could be paragraph 2. Talking about the law and protection offered to trespassers could be paragraph 3, if that needs to be included in the essay. Talking about protection offered to children could be paragraph 4. Talking about the protection offered and the liability for tradespeople and independent contractors could be 5th paragraph, and then defences, paragraph 6. I hope that helps you in preparation of your essay. Any questions, please just write them in the comments. Okay, so I'm going to spend the last part of this tutorial going through structures of the other areas of law and how you can set them out to gain maximum marks in your scenario questions. Okay, so your negligence scenarios, and it is pretty certain that you're going to have a negligence scenario because we know that occupier's liability will be the essay. Okay, what I can't advise you on is how they'll be split across the 2 parts of the exam, but you will have a negligence scenario. So for all of these areas of law, what I've done is put them into 6, so you can basically make sure when you're writing your exam questions that you've got 6 areas to talk about. Okay, now what you need to know in terms of examining for tort for OCR is that the marks level up. So if you miss out some of the earlier stages in a structure, you may miss out later marks. Okay, so for example, with negligence, identifying whether a duty of care exists and applying the test if it doesn't already exist, that will be one of the earlier stages, level 1 or 2. To then move on to get level 3, level 4, you need to have established that already. Okay, so it's a leveling up exercise. Tort is examined differently from criminal law and contract law. Okay, so first of all, you need to identify whether a duty of care already exists. This is a recent change from 2018. The case of Robinson says that you should use a previous precedent if one exists. So, for example, we know from the case of Bolam that doctors owe a duty of care to patients. So if you had a scenario with a doctor and a patient, arguably you wouldn't need to apply the Caparo and Dickman test at all because you know there is already a duty of care that exists. Okay, I hope that makes sense. So identify whether a duty of care exists first, okay, and cite Robinson. So Robinson should be your first case. If a duty of care doesn't already exist, then you apply the 3-stage test from Caparo. Secondly, you identify whether there has been a breach of the duty, and again, you apply the test. It's the basic test of competence. So, would a reasonable, competent person doing that same role have they fallen below the standard expected? So, if it's, for example, a gardener, are they falling below the standard expected of a competent gardener? If the defendant in the scenario is a professional, then we would expect them to, we would judge them against the standards of that profession, should I say. So has the defendant fallen below the standards expected in that profession? And don't forget, if it's doctors, we have the update from the case of Montgomery, where we expect doctors to provide patient-centred care. So has that doctor taken into account the specific circumstances of the claimant patient. Okay. If the defendant is an amateur, so a learner driver, for example, in nettleship, we would expect them still to, we would judge them against the standards of a competent driver, so somebody who's passed their test. Okay. What will get you more marks is if you consider the factors in making your decision as to whether a defendant has breached their duty. And there are 4 risk factors. Not all are going to be relevant necessarily in a scenario. So how probable was the harm? How serious was the risk of harm? What is the cost and expectation of precautions taken? So what lengths did the defendant go to try and avoid breaching their duty? We don't expect them to do everything. Again, the duty is to take reasonable care. Okay. Are there any benefits to the risk of harm? Which isn't always going to be applicable. The case of what involves somebody in the emergency services. So of course, not every scenario will be based around that. Okay. Thirdly, has the breach caused the harm or the damage to the claimant? So you use the but-for test, similar, of course, to the criminal law but-for test. So but for the defendant's actions, the claimant would not have suffered harm or damage. We also use a remoteness test of damage. So how remote was the harm? Okay, how foreseeable was it? In other words, if it's not foreseeable, if it's too remote, then the defendant won't be liable. And if relevant, we apply the eggshell skull rule. So remember, it's similar to the thin skull rule in criminal law, but it's called the eggshell skull rule. So you take your claimant as you find them. Okay. So you've got identifying a duty, a breach of duty, whether the breach has caused the harm, apply defences if applicable. So has the claimant contributed to their negligence, or have they maybe consented? If it was a sport, for example, then perhaps there's consent there. And then you make a conclusion. Really importantly, you must advise on remedies unless the question tells you not to. So just a short paragraph at the end, what would be payable to the claimant? So could they claim for pecuniary or non-pecuniary damages, so monetary or non-monetary, and special versus general damages, so damages up to the trial or damages post-trial. More importantly, though, what could they claim for? So in a scenario, is it a loss of opportunity to become a professional footballer or dancer, etc.? Is it damages for not being able to work? Is it damages to maybe fix something, like damage to a car or something? So make sure that you advise what they could claim for, and that information should be in the scenario. Okay. If you really wanted to impress an examiner, then you could apply the damages test from Hadley and Baxendale. Essentially, what is reasonably foreseeable? If you're going to advise about injunctions, so court orders being made, remember that they are limited. Okay, so damages compensation should be the first port of call. Okay, so I hope that helps. Private nuisance, again in 6 stages. So you identify from a scenario who the claimant is and who the defendant is. The claimant must have an interest in the land. So you can't claim if you are not a property owner and if you're a child. The defendant has to have possession control over the land, neighbouring property. You need to identify the nuisance. So is it direct or indirect? And then identify whether it is an unlawful nuisance. This is based on reasonableness. So there are factors here that can help you to decide whether on balance something is reasonable or not. If there are, let's say, 3 factors in a scenario you think apply that make the nuisance unreasonable, maybe 2 that make it reasonable, then of course on balance you're going to say it is unlawful because it's unreasonable. Okay, so use maths in a way to balance up what you think. Remember, in civil cases, the standard of proof is much lower than criminal cases. So you're not needing to prove beyond reasonable doubt whether something is an unlawful, unreasonable nuisance, you're only looking at on the balance of probabilities. So if there are more factors in favour of the claimant in this nuisance being unreasonable, then it's more likely that that claimant is going to succeed. Okay, and that's how the courts do it. You apply defences if relevant. So is there planning permission? Is there statutory authority to carry out the nuisance? Perhaps the nuisance has been ongoing for a period of 20 years uninterrupted and continuous. Perhaps the claimants have come to the nuisance, although that's very unlikely to succeed if you read about the Coventry and Lawrence case. And then conclude and again advise on remedies. Okay, so what would be payable and why? A paragraph at the end. Remedies is important if you're aiming for full marks in a scenario. Okay, Rylands and Fletcher. So what is the material that's caused the damage? Is it unnatural? It should be if you're going to find liability. Again, I would start with just identifying the parties, because for you writing these scenarios, it's easier if you understand who is the defendant, who is the claimant. Okay, so always start off by identifying those first. Has the material escaped onto adjoining land? If damage has been caused by fire, then the thing that's caused the fire must have escaped. It can't just be the fire that spread. That comes from Stannard and Gore. Is the thing likely to have caused mischief, and does it cause reasonably foreseeable damage? You then apply relevant defences, and don't forget to advise on remedies. The best thing to do is to, when you're going through each of these structures, pull up a scenario and practice. Okay, so don't just write out the law. You get more marks for application in this exam than you do law. So practicing scenarios is really key. Before the exam, you need to make sure you've practiced at least one more scenario. Okay. And vicarious liability. So again, I've put this into 6. So you establish the employee-employer relationship. So there's a 3-stage test to establish that, or whether the employer has benefited from the work that the so-called employee has carried out. Okay. The wrongdoing that's occurred, has that occurred within the employment, or is it connected to the employment if it's a criminal matter? Is it fair and just to hold the employer liable? And then conclude. Apply defences if applicable, not always, and advise on remedies. So you've got all the key law here, and I hope that these kind of 6 points for each of the areas of tort help you, but please do make sure that you practice to make sure that you understand how that works. And if there are any cases that you're not familiar with, please do look them up, because although you don't need to write about the facts, it's really useful to understand the context in how they've been decided. So on this slide, for example, make sure you understand the facts of Cox, and maybe Twine and Beans Express, maybe Lister and Halsey Hall, Mattis and Pollock. They're quite interesting cases. Mahmood and Morrison Supermarket and the Christian Brothers case. So make sure you look those up if you're not familiar with them at this stage. What I sometimes advise my students to do is to make a case law book and write out all the cases for each of their topics. If your exam is more of a way off, then you could maybe do that. Okay, what you might want to do on a big piece of paper is write those areas out that we've gone through in this. Sometimes I use this as revision, so just print this out and hand out. So you could draw this out, put it up on your bedroom wall so you can keep looking at it, or put it onto flashcards. I find sometimes a visual mind map can really help when you're in the exam. You can see things as they are. And what you could do is do one of these writing frames for each of the areas of law. Okay, so final tips. Plan your answers. As I said earlier, the examiners in Unit 2 Tort level up the marks. So if you miss out a stage, this can prevent you from gaining further marks. Always advise on remedies unless the question specifically tells you not to. Read the question. Make sure you read it and you understand what the areas of law are, because you could spend a long time writing about something else, and you're wasting time and wasting marks. Make a judgment on the facts as best as you can. Remember, in civil areas of law, it's about the balance. So you're not needing to convict someone beyond all reasonable doubt. This is about, is it more likely than not? If you, in terms of a conclusion, if you're not definitely sure whether somebody would be liable, that's okay. Just say they may be liable because X, they may not be liable because. It's absolutely fine to do that. Lawyers do that in everyday practice. It's very unlikely that you can ever advise somebody definitively whether they will win or lose. And always remember, cite relevant law, at least 5 cases / key legislation for each area. Okay, best of luck. I hope that helps you.